Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us, coming to you from Washington's premier indoor shooting facility. Of course, that's Security Gun Club right here in Woodinville, Washington. Hey, South Carolina. We have never had a chance to talk, and we are going to finally get a chance to talk about you. Now, normally, the way you end up on Washington Gun Law, regardless of what state you are, is that you do something so rotten, so nefarious, so sinister that we just feel compelled to tell the rest of the nation about your absolute rottenness. Of course, you allow your citizens to live free like Americans, but apparently you can't seem to really get a grasp on how to implement constitutional carry. Maybe we can give you some advice, but let's get everyone up to speed because this thing has garnered way too much attention and it's taken up way too much time and energy out of your state legislature that it should have. So today, let's geek out for a little bit and let's talk about what's the deal with constitutional carry in South Carolina. Okay, South Carolina, haven't had a chance to talk about you yet, and the reason is, of course, you do a fantastic job of allowing your citizens to live free like Americans, so much so that my favorite in-laws escaped the People's Republic of Washington State last year and moved to South Carolina where they're absolutely loving life. So this is for Allie and Nellie and my two wonderful nieces who now reside in your beautiful state. What are we talking about today? We're talking about House Bill 3594. What is House Bill 3594? Well, it has been given the name South Carolina Constitutional Carry Second Amendment Preservation Act of 2023. That's right. It was initially introduced in the House of Representatives in the South Carolina state legislature back in 2023. Kicked around there for a while and was passed out of the House in 2024, thus apparently sending the state of South Carolina well on the way to be the 28th constitutional carry state. That is a state that would not require government's permission before you could carry a firearm, so long as you were otherwise lawfully allowed to possess and own a firearm. Now, the bill, when it went through the House, it was a really, really nice, clean bill. And yet now, as you know, there's been all this attention because there appears to be this political tug-of-war. Everything seems to be mired down, and everyone's wondering, is South Carolina even going to get this done? And I'm going to try to explain, because a lot of viewers have said, hey, can you please explain what's going on in South Carolina? And rather than get too deep into the woods and get too much into the legislative language, we're going to kind of keep everything on the surface today and kind of use some illustrations. So, when the House passed House Bill 3594. Imagine that the bill looked just like this. Yeah, it was a really, really streamlined bill because what the bill had basically done is gone through all of South Carolina's firearm laws, and anywhere in which they referenced a permit or license to carry, it would just simply strike that from the statute. Therefore, there would be no references to an individual in South Carolina having to have a permit or a license to carry. Now, it tweaked a few other things and then also more definitively defined some of the gun-free zones in South Carolina. But then Governor Henry McMaster said, hey, listen, if you expect me to sign this bill, I want to see some additional penalties added for individuals who are committing crimes by stealing firearms or using stolen or unlawfully possessed firearms in the commission of a crime. What a wonderful idea. Actually address the real problem. And so the House obliged and put in some very clean language that would meet the governor's request, which is that, yes, there would be additional criminal penalties if you were using stolen firearms in the commission of a crime, if you were unlawfully possessing a firearm at the time that you committed a crime. And the bill passed out of the House with overwhelming support at that point. And so, as the bill headed over to the Senate, this is what it looked like. But see, then the Senate got their hands on it, and for whatever reason, every Tom, Dick, and Harry in the South Carolina Senate decided that they needed to continue to add amendments. And in fact, at one point, they added enough amendments to it that one actually questions whether or not this is even a constitutional carry bill anymore. Now, if you want to geek out on both bills, we'll link them up down below, but all you really need to know is that the House bill, even though we call it a nice, clean, streamlined bill, still had 22 sections to it. However, the bill now, as passed by the Senate, has 29 sections. And those 7 additional sections essentially neuter what was a very, very clean bill. And so essentially why the House bill may have headed over to the Senate looking like this, the Senate has now sent the bill back to the House looking a lot more like this. And predominantly the big problem is the newly amended and added to it sections 23 and 24 by the South Carolina Senate, which basically establishes mandatory training in order for the South Carolina government to continue to issue permits, as well as to come up ways for funding it. But in addition to that, section 24 of the bill does something far more sinister, because it increases criminal penalties, that is, adds a criminal enhancement for an individual who used a concealed firearm in the commission of that crime. However, those penalties would not apply, that is, the individual would be exempt from it if they had a South Carolina concealed carry license. In fact, the new sections specifically read, A person convicted of committing or attempting to commit a crime involving a concealable weapon, as defined in law, in violation of offense listed in Chapter 23, Title 16, or a violation of Section 10-11-320, must be in prison not to exceed 3 years. A term of imprisonment imposed for violating this section must be served consecutively to any term of imprisonment imposed for the underlying offense and may not exceed the actual sentence imposed for the underlying offense. This is what we call in criminal law sentencing enhancement, which means you're found guilty and then the jury also finds beyond a reasonable doubt of additional facts, which allows the sentencing court then to tack on additional time. Now that's pretty brutal if you use a concealed weapon in the commission of a crime. But check what else this section says. This section does not apply to a person with a valid permit to carry a concealable weapon issued pursuant to Article 4, Chapter 31, Title 23, provided that the permit was valid at the time the crime was committed. Did you catch that? So, if you are exercising your constitutional right to constitutionally carry and you commit a crime, you can be tapped out for additional prison time. But if you happen to have acquiesced to the state's permission scheme first, yeah, those additional penalties will not be added. So one really questions, what sort of constitutional right does this bill now preserve? Now, there's additional concerns because they added all sorts of other sections that say that FFLs and everyone else needs to keep informing people of the need to continue to get licensed, even though this provision would actually allow for constitutional carry. Now, this is passed out of the Senate looking like this, which means it's gone back over to the House. Do you suppose that the South Carolina House has accepted the bill as the Senate has amended? Absolutely not. Would you accept this car in exchange for this car? So now with the two chambers unable to reach an agreement, what they have called for is a conference in which members of the House and Senate will sit down and try to reconcile these two bills. But South Carolina, let us remember that this process started all the way back in 2023. And what shocks me in a state like yours that clearly does look out for the inalienable rights of your citizens is that this was an incredibly easy process. It surprises me it took the House as long as it did to get it out of its chamber. And now for the Senate to have completely mucked this up, one questions whether or not you're ever going to get this done this legislative session. Listen, like I said before, we'll link up both the bills down below so you guys can geek out on it for yourself. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is also down there in the description box. And then let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.